Good afternoon and welcome to this segment of King County Law Library's What to Expect When. Today's guest expert is a returning expert, Rosemary Lemoyne, who's going to join us to talk about the new set of abusive litigation forms on the state court form site. Welcome, Rosemary. It's a pleasure to have you back.
Thank you, Rick. I'm always happy to help the library in any small way I can because the library does so much for all of us, not just lawyers, but the public, and it's a wonderful resource.
Well, thank you for that. So the abusive litigation motion and order are up on the court's website. What are they all about and what are they for?
Well, in January of this year, 2021, our state recognized that abusive litigation was something abusers, the opposing party in a domestic violence relationship, were using to continue the abuse, to continue contact with the opposing party, and sometimes to impoverish the opposing party because attorney's fees, going to court, losing time from work, all of these took a tremendous toll on the victim. And so the state enacted a law allowing victims of domestic violence to file a motion seeking relief from abusive litigation.
People involved in situations that have already had a finding of domestic violence?
Yes.
Of the court?
Yes, this law applies just to a certain group of people. And you want to look at the law. Anytime you want to look at a law and see what it says, if it applies to you, if you have a computer, you can type into your computer search engine the title of the law, which is RCW 26.51.010. That stands for Revised Code of Washington, and 26 is the chapter. But this law applies to you if you are the current or former partner and the other party was found to have committed domestic violence against you. Now, the domestic violence order does not have to have been entered within the last year. As long as the domestic violence order was entered within the last 5 years, you still qualify under that basis. Remember, it's 5 years from the date you obtained the order. So if you obtained the order January 1, 2017, it's 5 years from January 1, 2017. The other way in which you may qualify under this statute, this law, is if you and the other person had a child or children together and you have a parenting plan that contains what we call RCW 26.09.191 restrictions that are based on violence, domestic violence. It has to be that type of restriction. You'll find that in your parenting plan and it will say the reasons for the restrictions. And another way that you may qualify, you should qualify to use this statute or law, is if there's a restraining order entered to protect you and the restraining order specifically stated violence was the reason for its entrance by the court. So it'd be something like restraining order saying the opposing party cannot come within so many feet of you because of violence, because of a history of violence. That will qualify you to file a motion to stop the opposing party's abusive litigation. And there are things I want to be sure everyone knows in terms of abusive litigation. What is it? Because sometimes, Rick, people will think abusive litigation is just a motion, but this law is much more expansive than that because the law states that litigation can include a motion that hasn't been filed with the court. Perhaps the opposing party has threatened you, has told you, I'm going to take you to court, and here it is. Here's this complaint I'm going to file against you. Or here's this petition. I'm going to try to change the parenting plan and get custody of our children. Even if he or she has not filed that with the court, you still are able to file a motion to stop abusive use of litigation. So it either is a motion he or she has filed or threatened to file. It can be an action, a petition to modify a parenting plan, for example, or a complaint for damages against you. It can also be discovery, what we call discovery. So that's interrogatories, written questions to you. I've heard of people receiving hundreds of pages of questions that they have to answer. And if you fall into the category of a victim of domestic violence that the law sets forth, you can file a motion to stop abusive litigation. Discovery that may be considered abusive could also include subpoenas for information. It's called a subpoena ducis tecum, and it would be sent to, for example, your employer, your school where you're attending school, your doctor, your counselor, your bank. If it's not for a valid purpose, if you know that the purpose is to harass you, to intimidate you, you can file this type of motion.
Okay. And so a couple of technical things that come to mind, Rosemary. We are filing this motion and proposed order using the case number that was the domestic violence case, or the case where a finding of domestic violence was imposed or recognized by the court in one way or another, correct?
That's correct.
Not a new case number. Okay.
You would use the domestic violence case number, but let's assume, for example, the former partner has filed a brand new action against you. You can use that brand new action's case number and provide the court a copy of your domestic violence protection order or the restraining order from the other cause. And this brings to mind something, Rick. A lot of times we have folks move into King County from another county or another state. If the domestic partner has followed you here or filed something here in King County, you can obtain a copy of the order entered in the other state or the other county. Call the county clerk that issued the order and ask them, how do I obtain a certified copy? Now, certified copy is what you want to provide to the court if it's an order from a county other than King County and you're here in King County filing your motion. But if you don't have a certified copy, if you only have a regular copy, provide that to the court and let the court know you've asked for certified and you should receive it within how many weeks or days the other court clerk has told you, and you'll provide a copy of that to the court as well. So that's important.
Yeah,
and
thank you.
When you talk about filing the motion, you can either file your own motion in response to the motion filed by your opposing party. You can even include it in your response. So if you're responding to a motion that is without merit, you should say in there, this motion is filed by my former spouse and it is without merit. There is no evidence to support it. I ask the court to make a finding that this is an abusive use of litigation and enter orders protecting me from that. But you can also initiate your own motion. If you're concerned or afraid your opposing party is going to file a motion against you or he or she has threatened you with one, you can start the action on your own. It's free. The court does not charge you a filing fee. So if you've just moved to King County and your former partner is threatening you in that way, you would contact the clerk to find out how to initiate the case, how to obtain a new cause number, we call it, for the case. The cause number is how the court files it. It always appears on the first page of the document, and it's going to be on the right corner. You'll see it, number, and then the blank line.
Okay. One more technical question. In many cases, when you're filing a motion and a proposed order, you also include a declaration. The court did not provide a blank declaration to go along with this motion and proposed order. Is that a problem?
Well, the motion form itself, when you sign the motion on the last page, you'll see that you're signing under penalty of perjury. So the motion will include your statements about these are the motions that my former spouse or former boyfriend has filed before or former girlfriend has filed before. So when you sign this motion, it's like a declaration because you're swearing under oath that this is the truth. Now, if you want to file a declaration with this, if there's more information you want to give the court, and there's just not enough room in the motion form to do that, there are declaration forms that you can use available for free from the court's website, Washington State Court's website. from the King County Superior Court's website, and the Law Library, which is public, free, open both to lawyers and to non-lawyers, can also help you find a form to fill out and use. It will have the ending paragraph that you're going to see on your motion. I declare under penalty of perjury, under the laws of the state of Washington, that the facts I have provided in this form, and you just say in this declaration, are true. Signed at, and then you place city, state, on, and then the date, March 12th, 2021, and then your signature, and you also print your name under your signature. So you can make your own declaration if you need to. The court can issue an order telling your former spouse or boyfriend, because or girlfriend, this applies not just to former spouses, former partners. If you're over the age of 16 and you have someone you dated who was abusive towards you and a finding of domestic violence happened, you too may be able to file a motion to stop abusive litigation. You don't have to have lived together. But in any event, the court can award you attorney's fees if you hired an attorney. The court can award you lost cost if you lost time from work, provide something proving how much you earned. The court can give you that. If you hired an attorney to help you, provide a copy of the receipt showing what you paid. The court can require the opposing party to ask the court's permission before the opposing party takes any action in court, and that can be put into effect for a period of time that's fairly lengthy. And so it's very helpful because you have the protection of the court surrounding you for several years. And the court can, of course, strike the motion, which is what you want the court to do, or strike the discovery request.
Mm-hmm. Well, thank you very much, Rosemary. That was a wealth of information that will help people use these new forms that are in the situation where they're facing abusive litigation process. Thank you.
Oh, thank you, Rick, very much. And thank you for all the library does. It's a wonderful resource.
Thank you.